Pavel Batishchev. He's managing partner at Aurum and co-founder at DAObox. So Pavel is going to talk about legal practice developments against DAOs, decentralized autonomous organizations. So all DAO fans, listen carefully. Impacts on structuring solution. Plus, so Pavel, your turn. 20 minutes for talk and Q&A. Guys, don't forget to ask questions. So I'm turning off my camera.
Having me, my presentation is about recent developments in legal practice in DAO structuring. So let me start. A short disclaimer that everything that will follow is just my opinion, not a legal advice. So I would like to talk about the case of Andrew Samuels versus Lido DAO, and if I have time, also touch a bit about recent guidelines of European Securities and Market Authorities under market and crypto asset regulations, and some ideas about using DAO structures in structuring RWA SPVs. But the main topic is Andrew Samuels' case with Lido DAO. So this is not something very new, because we already have several cases against decentralized autonomous organizations. We have a case against Compound DAO, we have DAO case, but this case is a good reminder and maybe one more evidence and in a bigger discourse about how DAOs should be structured, what legal structure they should have. So this is what was the essence of the case. There is a US investor in crypto, Andrew Samuels, who bought tokens of Lido. For those who don't know, Lido is one of the most significant blockchain infrastructure protocols for restaking of Ethereum. They amassed, I believe, around like billions of total value locked. So it's a very significant protocol, therefore, and case is also very significant. There are other defendants in this case. So yes, Andrew Samuels bought on secondary market on exchange tokens, get some loss on that trade, and decided to sue Lido. There are other defendants in this case, Anderson Horowitz, A16Z, Paradigm, Dragonfly, and Robert Ventures, major investors to Lido. As of now, the case is still in progress, and how I understand it, in the US, when the lawsuit is filed, to District Court of California, there is an opportunity for parties, for defendants to ask the court to dismiss the case on different grounds, like procedural, for example, lack of capacity to sue or to be sued, or jurisdictional, wrong jurisdiction. But it's also an opportunity for parties to present arguments and to see how they're viewed by their other party, by the plaintiff, and by the court. And as of now, we're at this stage. There was filed a motion to dismiss the case, and in November, the court ordered to deny these motions. And we now understand that the position of the court, which is self-evident in the citation I offer on this slide. So everything is bad towards DAO, and we will analyze that. So the case have two components: decentralized autonomous organization and securities, offering of unregistered securities in the United States. I will omit everything regarding securities because this topic is much more well understood now. There are lots of practice where the main concern for us is DAO practice. So what happened and what are the main questions of this case? They are similar to those who are familiar with Compound DAO case. So the court is to decide whether the DAO can be sued, and if it can be sued, what it is, what type of, if it is a legal entity, what type of legal entity it is, the allegation that it's a general partnership. And there are other major investors, contributors to the DAO. Investors Paradigm, A16Z, Anderson, Dragonfly, Robert Ventures, and the court is about to decide whether they are members of this general partnership, and if yes, are they liable for the violations committed by the partnership, by the DAO. So the upshot now is that yes, the answer to all those questions are affirmative. The court decided that agrees with the plaintiff that DAO can be sued, that DAO is a general partnership, and mentioned participants are members of that general partnership and can be held liable. During this phase, parties presented their arguments, and the position of Lido and position of other defendants was that Lido is a set of smart contracts. The notion that we're all familiar with the strategy, which was like there for many years, that Lido DAO is a set of smart contracts and they can be directed by users directly, by any stakeholders, and that they can be a fork of these smart contracts. Anyone can, they are open source, anyone can run their copy of Lido smart contracts, and that it's not a legal entity, it doesn't exist in like a legal system, it doesn't have any jurisdiction. The position of the plaintiff with which the court agreed is that the most important is not whether smart contracts are immutable or automated. The most important who deployed these smart contracts, who run them as a business. And position of the court and the plaintiff that these people who are involved are players are identifiable. There are founders who deploy the smart contracts, who ran the DAO as a business, who engaged investments, who made efforts to launch the token, to facilitate the secondary market, and therefore to build this organization as it exists today. Not all the members of the general partnership are identifiable, but those who are identifiable are mentioned on this on this slide, except for Robert Ventures. And it's said that investors, not only contributors by merely because they provided capital, but because all of them are significantly, meaningfully involved in the governance, provided their recommendations on the governance, shaping the business, and so their participation is so meaningful that they are members of this general partnership. This interpretation is good that to the extent that we can assume that not all of token holders of the organization of the DAO are considered, at least in this case by default, members of the partnership, but still it's bad. So what's the main summary of this case? The upshot that yes, court denied the motion to dismiss the case, and therefore it will be heard, and there will be ruling in this case. But now we understand that the court shares the view that there is a general partnership exists under the laws of California, and therefore we can conclude that at least in the United States there is a risk for any DAO to be classified as general partnership with the lack of other legal structure, and that DAO participants, investors, token holders could face personal liability and could be recognized as members of partnership and subject to their meaningful involvement in the organization. And what is also very important takeaway here, of course, we all expect a wind of change in the United States, that federal regulators will have change in their policies more friendly towards the crypto industry, and that they will replace the practice of regulation by enforcement with something more sensible, with clear guidelines, and maybe we even expect that some new law will come. But still, this case shows us that DAOs are not only vulnerable to legal actions from federal regulators like CFTC or Securities Exchange Commission, but also from private parties like private plaintiffs in class action lawsuits. And here the changes could be much more slow unless a specific act would be introduced, because court practice and precedents, they develop over years. For example, as we know, how it is well known as almost 100 years old, and that's why it's very important to understand when we build structured solutions for decentralized autonomous organizations and when we develop the legal strategy. Some additional thoughts on this case. When I read it, as well as other decisions, not many against DAOs, and for example, recent investigation against market makers, or another cash case, I feel that the era when crypto and DeFi, decentralized finance, Web3, decentralized autonomous organization, everything was like a terra incognita for regulators and authorities. And I think now this era is over. And what I see from legal documents is that regulators and those who attack the industry gain necessary expertise, and they quite well understand what we are doing, understand our language, and that allow them to apply this very important for regulators principle, substance over form. In particular, in this case, we see that the court assessed the governance, assessed the proposals, assessed the answers to the proposals, identified key players, contributors, even if they are disguised with Discord handles or Twitter handles. And it's also important because I think, for example, the position of Lido representative was like a bit naive, as if we were in like year 2016, that law is code, and so the legal strategy was like very oversimplified, I would say. For those who are very interested in legal aspects of decentralized autonomous organization, I also mentioned on this slide, I recommend the scoping paper of Law Commission of England and Wales. It was published last year. It's a very comprehensive document, 200 or even more pages, but it covers, I think, everything about a decentralized autonomous organization that was developed so far, all legal thought, overview of all jurisdiction, so very comprehensive research. Okay, so what are our conclusions and how this impact structure and solutions? When as I said, this case is not like something extremely new. We had a similar case against Compound DAO, but I think it's once again reminder us that we need to rebuild the legal strategy when we when we develop DAO structures. And over years, our legal strategy changed. We started in early days with the notion that DAOs, they don't need legal wrappers at all, and that code is law, and DAOs a bit an archaic concept that we do not recognize traditional legal or financial systems, and no need any legal entities at all. Then just because of practical needs, we understood that sometimes the DAOs need to hold assets, need to make payments, they need to manage contributors, make other transactions, and for that purpose need some, so to say, legal anchor or a legal entity, legal wrapper. This is how the concept of legal wrapper emerged, and the first use case was the so-called partial legal wrappers. The best example is Foundation. So partial legal wrapper is essentially a structure which is sitting nearby the DAO, doesn't absorb the DAO, and performs a specific function. For example, IP management, running grant program, holding assets, managing contributors. But it doesn't absorb the entire DAO and doesn't provide, therefore, token holders with protection by default. The best example of such a structure is Cayman Islands Foundation. I think one of the most widespread and choice for many organizations like Arbitrum, ENS DAO, and many others. But again, the limitation of this structure that it doesn't offer legal protection to token holders and the DAO by default. It still provides some legal protection in transactions where the foundation partial legal wrapper is counterparty. For example, if foundation enters into agreement with some third party, the foundation will provide the DAO with legal protection in this particular transaction because it has limited liability. Then now, because of the case of Lido DAO, OK DAO, Compound DAO, we understand that we need probably the full protection for the DAO. And there are already several jurisdictions offer frameworks which we didn't have like a few years ago. In the United States, it's a decentralized unincorporated nonprofit association. In Wyoming, in Marshall Islands, DAO LLC that can be for profit and non-profit. For example, in the United Arab Emirates, a new crypto-free zone, RWA, which has a framework for decentralized association regime. So the difference with full legal wrapper that it recognizes token holders as members and provides therefore legal protection by default. So what talking about trends, we expect that given this legal practice against DAOs, the use of these full wrappers should grow. There are concerns, and why this discourse was so long throughout years, why we should not use these full wrappers, is that there was a fear that it will harm decentralization, that we will end up in entities like traditional corporations with management, directors and shareholders, and this will kill the very idea of decentralization and DAO. But I could say that today, because of these frameworks that are very flexible, and because of some structure and other structural solutions, we could still maintain decentralization and find the balance between the legal protection and decentralization. So again, I would say, not pretend that this is the most right view, and this is of course can be very debatable. But given this practice, it is good to have a full wrapper in a form of, for example, US decentralized unincorporated nonprofit association or Marshall Islands DAO LLC. But it is also possible to combine. It doesn't mean that we need to refuse to use foundations or other legal structure that we used to employ for decentralized autonomous organization. We can combine them. The only recommendation here that I will show it on the slide, that we should have as a base layer always full wrapper, or in other words, DAO-specific entity, which will recognize token holders as members by default. Of course, again, we have here flexibility for those DAOs that would like to offer their token holders an opportunity to opt in or opt out of membership. It is also possible. For example, in Marshall Islands and C, it can be structured. Then to mirror the structure of comprehensive DAO, we can have operational layer when we can create additional structures. It can be in the form of subsidiary companies that are subsidiaries of DAO LLC, or it can be foundation. In Marshall Islands, it's also possible to create on the master structure of the LLC series, which can have segregated liabilities, segregated assets, and even their own token holder members and token holders. What is also good and important about member-managed organizations such as DUNA or DAO LLC. In these organizations, we don't need to have a board of directors or officers. This is member-managed organizations. Therefore, we can mirror the governance and without harming decentralization. But we can wrap the entire organization, and at the base layer and at the operational layer, we can wrap sub-DAOs, different committees, grant programs. But again, this all will have, now we have enough tools to offer legal protection and full wrapping for all elements of DAO, which was not the case like a few years ago. Okay, I see already that I'm running out of time, even exceeded my time, sorry. Yeah, thank you.
Well, that's problem. So I certainly think that we've learned that it's quite easy how this old-fashioned law precedent system based on common law, especially gas, is evolving on the frontier of intersection with such technologies, innovative technologies like decentralized terms organization. So this is the cutting edge, extreme frontier. I have a question for you, Pavel. From your viewpoint, what are 3 key judicial precedents or legal cases, whatever you name it, regarding decentralized autonomous organization on the web, the most renowned, most well-known? For instance, one of them is the DAO case. What are the other 2 you would like to mention? For all lawyers, need to be studied. 3 legal cases.
Well, I've mentioned, I think, the most important Lido case and compound case, which are similar. And the other one is DAO case. The difference there is that it was initiated by the federal regulator in the United States, the CFTC, Commodities Futures and Trade Commission. But what is similar in all of this case, the attempt to pierce the decentralization veil of DAO and to hold accountable the members of the DAO. This is what is similar. In compound case and Lido case, we are still waiting for final rulings, final judgments, but we already understand the trend and can anticipate the result, expect what will be the results of this case. So yeah, they give us a lot of materials to think about.
Well, your professional job is extremely interesting. So I have a sort of wide empathy here. Thank you very much. We've learned a lot. It's been extremely useful. So guys, if you are not a legal lawyer for DAOs, so Pavel can fulfill this role. Thank you very much. Please stay tuned till the end of the event in the chat. Maybe somebody will ask questions. Right now we don't have questions for you, but nonetheless it may appear. So thank you.